All right, let me show the court's in session here. There were actually two cases that were scheduled this afternoon. Case number 14 CR 493. This is the case where there's indictments for aggravated murder, and tampering with evidence. That was set for a pre-trial today. The second case, case number 14 CR 494, Ohio versus Jermaine Ruth. This is the indictment for drug trafficking and heroin, and with a forfeiture specification for a 1988 Oldsmobile. That was scheduled today for a pretrial and a plea deadline hearing. The state of Ohio is present on both of these cases, represented by Mark Draper, assistant prosecutor. The defendant, Jermaine Ruth, that is your name, sir?
Yes.
Is present. He's accompanied by his retained counsel, Jimmy Mack Jr. on both cases, 1:30 p.m. So we'll hold a pre-trial at that time. And just for the sake of the press, normally when we have capital cases, I hold pre-trials on the record and the public's invited to attend. If it's anything less than a capital case, this is not a capital case. The pre-trials will be conducted in chambers, and unless there's some decision to be made or something to be put on the record, we probably won't be in the courtroom. So what we're going to do today, make a long story short, we are going to proceed at this time with case number 14 CR 494, and it's my understanding the parties have reached a plea agreement on this case. In this case, there's an indictment for one felony of the 5th degree offense. So let me ask Ms. Draper, is there something to come to the court's attention on the 494?
That my client at this time will be withdrawn on strong family in the plea of not guilty, and will in fact be in the plea of guilty to the count one, the earlier count in the indictment. He also will be entering a plea of guilty to the forfeiture. I think there's a specification for that as well, Your Honor, and that is my understanding as well. That a PSI will be asked for and referred to adult probation department for that specification.
All right, then, Mr. Mack, before the court determines whether or not it should accept your plea of guilty in this case, there's some information I want to give to you and some information I want to receive from you. So let me ask you first, how old a man are you?
34, I'll be 35 this morning.
You're 34 today, incarcerated.
We moved from the last address because of my case that got publicized in the paper, so I don't have an actual address right now.
What was your last address then?
The last known address was 5306 Alabama.
The mother of your child. Okay. Now, are you a citizen of the United States of America?
Yes.
And what's the highest grade you completed?
I have a degree.
May I presume that you can read and write the English language?
Yes, sir.
Can you understand what's been said so far in this proceeding?
Yes.
Now, I understand you're incarcerated, but I'm going to ask you for the record, have you consumed any medications, any alcoholic beverages, or any drugs in the last 24 hours?
No, sir.
Do you have a clear mind at this time?
Yes.
You're not sick, dizzy, drowsy, or under the influence of any substance? You know how long you've been in jail on this particular case?
Yes. Since July of last year.
Do you remember what date in July?
Like the 29th.
Your Honor, if I might, I think it was the 31st.
July 31st?
Yes, sir.
You've been in jail continuously since that time. We can compute the number of days later. Right now, your attorney, Mr. Jimmy Mack Jr., has been retained or hired by you or your family?
Yes.
Okay, do you have any complaints you want to make about how your case has been handled so far?
No, sir.
Have you had enough time to talk to your attorney about this plea agreement and about this verdict of forfeiture?
Yes.
You need any more time right now to speak to your attorney privately before we go on further?
No, sir.
Now, let me explain some things to you. First, I want to explain the nature of the charge. Under the indictment, it's alleged that on or about August 7th, 2013, in the city of Ashtabula, county of Ashtabula, and state of Ohio, you, Jermaine L. Ruth, did knowingly sell heroin or a compound mixture, preparation, or substance containing heroin in an amount less than bulk, to wit, 0.5 of a gram, or it'd be 1/2 of a gram of heroin. That's a minimal amount, contrary to the form of the statute. So, knowingly means you're aware of the circumstances. So in this case, it would mean that you knew this substance you sold did in fact contain heroin. Now, there's also a specification that was attached to the indictment, and the specification reads as follows. The grand jury further finds and specifies that the defendant's right, title, or interest in the following items shall be subject to forfeiture to the state of Ohio. The property having been used in any manner to commit or to facilitate the commission of the felony Oldsmobile, Ohio registration FXX 5654, and it has a VIN number. The last 5 digits are 17177. So what that specification means is that this Oldsmobile was used in some manner to facilitate the sale of this heroin for the drug abuse offense. So do you understand what the forfeiture specification is?
Yes, sir.
If you use property to facilitate or commit an offense, you lose title or ownership to it, and if the state has a forfeiture specification, they can take the property as long as you did in fact use that property to commit the drug abuse offense. You understand what that is? All right, next I want to explain to you the penalties that may be imposed in this case. This is classified as a felony of the 5th degree, and the law provides the following possible penalties. First of all, the court can impose a term of prison incarceration of not less than 6 and not more than 12 months. So you can be imprisoned between 6 and 12 months. Also, you can be fined monetarily up to, but not more than, $2,500. Now, neither the prison term nor the fine are mandatory penalties. By that I mean the law doesn't mandate or require that the court impose those 2 penalties. But the court can impose each of these penalties in its discretion. There is a mandatory penalty consisting of a driver's license suspension. That would be at least 6 months in duration. It could be as long as 5 years. The court would determine how long to suspend your driver's license. But the driver's license is mandatory. There will be a driver's license suspension of some sort. Also, on the forfeiture, if the court grants the forfeiture of the motor vehicle, the 1988 Oldsmobile, that means any ownership or title interest that you have in that vehicle would be transferred to the Ashtabula Police Department. You're going to lose ownership of it. Do you own that vehicle? What interest do you have in the vehicle?
All right.
Who owns the vehicle?
A shop.
A shop.
Yeah.
So Matt, can you explain,
Well,
if he doesn't own it, it's kind of crazy to be forfeiting with no interest.
yeah, he's giving up any interest in it whatsoever, Your Honor, because it doesn't own it, so.
Once you completed your prison term, you would be released from custody, and you could be made subject to post-release controls. Those are certain conditions that you'd have to live up to and abide by even after you served your prison term. Now, in your case, post-release controls are not mandatory in this case, but they can be imposed in the discretion of the Ohio Parole Board. If they are imposed, the maximum period of time that you could be subject to post-release controls would be 3 years. Now, if you receive a prison sentence in this case, and if upon release from prison, you're made subject to the post-release control sanction, you could have a new prison term imposed of up to 9 months in duration. However, the total of all such new prison terms cannot exceed 1/2 of your original sentence. I already told you the maximum sentence you can receive is 12 months. Half of that's only 6. And you might even get a sentence less than 12. Now, as an alternative to a prison term, on this charge, you're eligible for community control. That's what we used to call probation. If the court determines to impose a term of community control upon you, you could be subject to those conditions for a maximum period of up to 5 years. Now, that doesn't mean you have to be on community control 5 years. What it means is it can't be any longer than 5 years. It could be shorter. An option would be for the court to impose a more restrictive community control sanction. The court could impose a local jail sentence, or it could impose electronically monitored house arrest, something of that nature. The third and last option for the court would be to terminate community control and to then impose a term of prison incarceration upon you. So let me ask, do you have any questions about the possible prison term, post-release controls, or your eligibility for community control? Okay, this gets a little complicated. If you're not sure, you ought to tell me. Think you understand what I've said to you? Okay. If you went to trial and were convicted by the court and jury, you'd have a right to file an automatic appeal under those circumstances. Then on appeal, you could raise the question of whether or not the evidence that was offered during the trial was strong enough to support the conviction. The reason you can't do that on a guilty plea is because the highest form of evidence that the state can offer against you is your own admission that you did commit the act you're pleading guilty to. Now, I'm not sure that this case has been scheduled for trial yet, but if you wanted a trial, you're entitled to have a trial on this charge. On the date of trial, the court would summon approximately 50 people to appear here as prospective jurors. That first group of 50 people is selected by a computer. The court does not pre-select who these jurors are going to be. You don't pre-select them, and neither does the state of Ohio. The first thing we would do on the date of trial would be to select 12 of those 50 prospective jurors. When we select the 12 actual jurors, you do participate in that process. You're permitted, through your attorney, to question the prospective jurors. The goal is to pick 12 people who could be fair and impartial, 12 jurors that are not familiar with the facts of the case. The defense usually wants 12 jurors that are not related to any alleged victims or the state of Ohio. And the state of Ohio wants 12 jurors that are not related to you. Try to find 12 people that can come into court, listen to the evidence that's offered during the trial, apply the law that the court would instruct is applicable, and a jury that can reach a verdict basically on those two elements, the evidence and the law. Now, once that jury was selected and the case was tried, before you could be found guilty, all 12 jurors would have to agree unanimously that your guilt had been proven beyond a reasonable doubt. Before you could be acquitted or found not guilty, all 12 jurors would have to agree unanimously that your guilt had not been proven beyond a reasonable doubt. So to get a verdict from the jury of either guilty or not guilty, all 12 jurors must agree on that verdict. If the 12 are unable to reach a unanimous verdict, if they're divided in any number, the number might be 6 to 6, could be 10 to 2, maybe 1 to 11. It doesn't matter what the number is. If the jury is divided, that means that no decision has been reached. It's what we call a hung juror. In that case, the matter would have to be rescheduled and retried again to a different jury panel. During the course of the trial, the burden of proof is on the state of Ohio. The state filed this charge against you. You don't have to prove anything during the course of the trial. During the trial, you have the right to exercise compulsory process. That means you have the right to call witnesses to testify in your defense, and you have the right to compel the attendance of those witnesses at trial. You compel a witness's attendance by having the witness subpoenaed before the trial starts. Understand what I've said so far to you?
Yes.
All right. Let me ask counsel, were there any searches and seizures conducted in connection with this investigation? Were there any statements made by Mr. Ruth on the law enforcement agents?
No, Your Honor, this was an undercover guy.
I agree, Your Honor.
No searches and no statements?
No, sir.
And we'll go on. Next right I'd like to explain to you is you do have a right to file an appeal. Any final judgment entry of this court. Filed your appeal with the 11th District Court of Appeals. It's a 3-judge court. That court sits in Warren, Ohio. What it does basically is review a transcript of proceedings from this court. Any questions now? Anything you want to ask me about anything that we've done over so far? Okay. Let me ask, Mr. Ruth, are you in court this afternoon of your own free will in entering a plea of guilty to trafficking in heroin, a felony of the 5th degree?
Yes.
Has anybody made you any threats or any promises in order to induce or coerce or force you into entering this plea?
No, sir.
Is this plea something you decided to do, I presume, after talking to your attorney and obtaining discovery information from the state of Ohio?
Yes.
Is that correct? Okay. Do you understand that if I accept your plea, there isn't going to be any trial in this case?
Yes.
You understand further that some of these rights that I've just explained to you are rights that are typically exercised during a trial. Once again, that was your right to require the state to prove you're guilty. Well, then let me ask you, what happened on or about August 7th, 2013 that caused you to be indicted for trafficking in heroin? This occurred in Ashtabula City, Ashtabula County, Ohio. What did you do on that day?
I met somebody somewhere to deliver some drugs. I mean, they got me on camera or whatever, photos. I mean, too much to debate.
Did you actually offer or sell some heroin on that tape to somebody?
Yes.
As I indicated, the elements that you did knowingly sell. Knowingly means you're aware of the circumstances. What it would mean is that the material or compound or mixture that you sold, you knew contained some heroin. That's true?
Yes.
Okay. And the amount of the heroin was a minimal amount. It's 0.5 or 1/2 of a gram. It's a small amount. Less than bulk. Is that correct?
Yes.
That this property was used in some manner to commit or to facilitate the commission of the felony drug abuse offense or act. Did you drive that automobile to the area where you sold this heroin?
Yes.
Okay, so it got you there and probably took you back home afterwards, correct? But you're stating you don't own this vehicle.
Your Honor, if I could be heard on that, I have a printout from the Bureau of Motor Vehicles that indicates that Mr. Ruth is indeed the owner.
All right, well, you're probably going to have to inquire into this. It sounds to me, and I'm kind of guessing here, but it sounds to me like it might be in a shop for repairs and the shop owner might have a lien on it. If he hasn't come over here, you can obtain title with a type of repair lien, but perhaps he hasn't done it yet. Let me ask Mr. Ruth, it is your desire to, and I believe you have already signed the form that was entitled verdict of forfeiture. I think I got your signature on here and your attorneys. You remember signing that?
Yeah.
Before? It is your intention then to give up and turn over to the Ashtabula Police Department whatever interest you have in this motor vehicle.
Yeah.
If you're the owner, you're giving them title. If you're not the owner and don't have any interest, then you're not giving them any interest. But whatever interest you do have, you're voluntarily giving, you're forfeiting to the state. You're going to lose any interest in this car. You understand that?
Yeah.
Okay. All right, well, the court notes that the defendant has signed the verdict form. It's also been co-signed by Prosecutor Draper and by Defense Attorney Mack. And the court finds that the defendant understands the verdict of forfeiture. He's admitted that he used this motor vehicle to get to and to leave the scene of the sale of the heroin. And the court finds that the verdict of forfeiture has been signed voluntarily, intelligently, and knowingly. And the court is going to execute the verdict form now. That this property was used in some manner to commit or to facilitate the commission of the felony drug abuse offense or act. Did you drive that automobile to the area where you sold this heroin?
Yeah.
Okay, so it got you there and probably took you back home afterwards, correct? But you're stating you don't own this vehicle.
Your Honor, if I could be heard on that, I have a printout from the Bureau of Motor Vehicles that indicates that Mr. Ruth is indeed the owner.
All right, well, you're probably going to have to inquire into this. It sounds to me, and I'm kind of guessing here, but it sounds to me like it might be in a shop for repairs and the shop owner might have a lien on it. If he hasn't come over here, you can obtain title with a type of repair lien, but perhaps he hasn't done it yet. Let me ask Mr. Ruth, it is your desire to, and I believe you have already signed the form that was entitled verdict of forfeiture. I think I got your signature on here and your attorneys. You remember signing that?
Yeah.
Before? It is your intention then to give up and turn over to the Ashtabula Police Department whatever interest you have in this motor vehicle.
Yeah.
If you're the owner, you're giving them title. If you're not the owner and don't have any interest, then you're not giving them any interest. But whatever interest you do have, you're voluntarily giving, you're forfeiting to the state. You're going to lose any interest in this car. You understand that?
Yeah.
Okay. All right, well, the court notes that the defendant has signed the verdict form. It's also been co-signed by Prosecutor Draper and by Defense Attorney Mack. And the court finds that the defendant understands the verdict of forfeiture. He's admitted that he used this motor vehicle to get to and to leave the scene of the sale of the heroin. And the court finds that the verdict of forfeiture has been signed voluntarily, intelligently, and knowingly. And the court is going to execute the verdict form now. One last time, is there anything you want to ask me? Is there anything you're not sure of? Any questions you have? Okay. Well, the court finds that the defendant, Jermaine Ruth, is before the court. He's been accompanied by counsel throughout these proceedings. The court finds he understands the nature of the charge of trafficking in heroin. He understands the maximum penalties, his eligibility for community control, the effect of the plea of guilty, and all of the other legal and constitutional rights that have been explained in detail. Based on Mr. Ruth's statements, the court finds that he has admitted his commission of this offense. And the court is now satisfied that the plea is being tendered intelligently, voluntarily, and knowingly. The court will accept the plea of guilty to the charge in the indictment, and the court has already accepted the plea on the verdict of forfeiture form, and the court has executed the verdict of forfeiture. So the court will accept the plea of guilty to trafficking in heroin, and the defendant now stands convicted of that offense. So is there anything else to come to the court's attention at this time on case number 14 CR 494?
Nothing further, Your Honor.
Nothing further, Your Honor.
Very well, and that'll be all at this time.
Jamie, see you later.
Okay, thank you, Marcus.
All
Oh, Amy? Judge, have a great day.